Good morning, everyone, and thank you for joining our H2A webinar today discussing the process, compliance, and AEWR rule update, and some other miscellaneous information about the program that many of you are already participating in. We appreciate you joining us. Today, we'll be discussing just a brief overview, some step-by-step aspects of the program at large, requirements and compliance, common challenges, the 2025 AEWR Interim Final Rule, which affects all the H2A wage aspects, and the impact on employers and some case examples. We'll then, at the end, have a Q&A. I'm Associate Attorney Annalee Patel, and many of you have kind of seen me in the background of our conversations when you're talking about any compliance issues or even just case strategies. And later we'll be joined by Jessica Ash, who's a senior paralegal at the firm who has 4 years of experience on the H2A side. An overview of the H2A program essentially encompasses just a reminder that the H2A visa program is geared towards temporary agricultural workers. So employers get the opportunity to legally hire foreign workers for temporary or seasonal jobs when there aren't enough domestic workers available. And this program permits around a 10-month maximum certification period, which is different than what some of you are used to on the H-2B side, because on the H-2B side, it's a 9-month maximum. So what some H-2A employers can do is have either one big 10-month certification period, or they'll have 2 5-month periods that fit within their temporary needs. Typically, there's over 66,000 H-2A visas issued during the fiscal year of 2024, and this is around the same amount that are issued every year. And unlike the H-2B program, there's no annual cap on the H-2A visas. It's designed to help U.S. employers meet labor needs while maintaining compliance with federal labor laws. And it's a great opportunity for employers because it gives a compliant and reliable, as well as a scalable workforce solution for peak agricultural seasons. In addition, the H-2A visa category permits hiring of foreign workers, and that enables you to build a workforce with workers that you find are valuable. They're great on the ground. You want to see them return season after season. So this program lets you have a certification or two, depending on the length of your certifications every year, but also see a similar workforce every year. So you get you get confidence in your foreign labor force, as well as kind of assurances that you feel like you're going to get the same kinds of workers or the same group of workers, for example. A simplified process description is outlined from steps 1 through 7. Many of you will know that it feels much more complicated once you're going through the H-2A program, but just to kind of summarize the steps, the first step is when we're facing the government and our filing deadlines. We're looking at submitting a form ETA 790A to the state workforce agency. And this essentially gives the employer an initial clearance to post the job order and to kind of kickstart what is eventually going to be step 2, which is the actual ETA 9142A application for H-2A temporary agricultural workers. Both of these steps 1 and 2 are filed with the Department of Labor's flag portal. And as many of you saw during the government shutdown, when the Department of Labor is also inactive, the flag portal is not operational. So right now that the Department of Labor and the H-2A program specifically has been viewed as a necessity. We're able to now enter into the flag portal, kind of kickstart your applications again, and get through these steps in the timing allowed by the government. Naturally, we end up getting to step 3, which is testing of the US labor market. This is at the point where we work with the local state workforce agency or authority to conduct recruitment of US workers and submit an initial recruitment report. Once they're satisfied with our compliance of this step, the DOL will process our application and issue a full certification for the H-2A application. We're then able to take the certification and all the certified Department of Labor documents, including the certified 790A and the certified 9142A, and we file Form I-129s requesting H-2A workers under this application. In some instances, you're going to experience filing an unnamed I-129, which is essentially asking for workers to go through visa consular processing. And in other instances, you might be asking for a named I-129, which could be for a host of reasons. For example, if you want to transfer workers from a work site in the US to a different H application, we're able to do that. If they have a different status and you want them to join your H-2A application, we're able to do that. All of those look like a named I-129. So the circumstance could change in terms of how we file the I-129, but it'll always be called an overarching named I-129. Once we file that and it's processed, issued a receipt notice, and issued a approval notice, we're able to schedule consular processing, arrivals, and execute onboarding with you. So a lot of this actually ends up working in conjunction. For example, if you use AEWR labor, we're able to kind of do a few of these steps at the same time so that we can file the form I-129 on the legal side and work with the AEWR recruitment team to ensure the visa consular scheduling is done when you need them so your workers can get to the US close to the start date that you want them to. And then lastly, once the workers arrive, it's all about just ensuring we're complying with the program, that we're respecting the I-94 arrival and departure record, because just as a reminder for some of you, the I-94 arrival and departure record has a lawful status expiration period. So we always recommend employers, once workers arrive, talk to the workers, get a copy of their I-94, just make sure the I-94 expiration date matches what is the end date of the employment certification period. It should be around 10 days after the H application ends if the government provided that grace period that they're supposed to do. Now, sometimes we're seeing, especially as of late, we're seeing some errors on issued I-94s, and this is an issue that has to be funneled by the worker slash employer because they typically have to take their immigration documents, go to a deferred inspection site, or sometimes to an airport, and they're able to correct it in that way. There's no formal process necessarily that we can kind of file on your behalf that would make it as convenient for the worker or for yourselves as the employer, other than doing that deferred inspection site or the airport. But we're always open to helping. So let us know if you get any questions on your I-94s or you think something's off. Some employer and worker requirements. The employer must provide or prove a shortage of qualified US workers. In this sense, we utilize that recruitment stage of the process, but we also create some language in a support letter in the sense that if it's hard for you to retain workers, if it's been historically hard for you to get livestock feeders, for example, then we build that into what we call a support letter. So that's what ends up trying to prove a shortage of qualified US workers. as well as any other documents that we might ask you throughout the process. The employer must also offer wages equal to or higher than the adverse effect